the Tupac murder case, as the prosecutor said, Kefee D is trying to shop his story to Hollywood agents in order to help pay for his bail and his lawyers against the Slayer statue of Nevada. Ooh, let's get into some of this straight game.
Blackjack. Life is like some cards. It's not what you dealt, but how you play it. Play each situation correctly. I remember they used to laugh at a brother.
Welcome back, guys. Welcome back. It's your boy DELRAY Richardson, platinum artist, platinum songwriter, Straight Game TV. Thank you for tuning in. I appreciate your time. Do me a favor, click on the thumbs up button. Also, subscribe to the channel if you have not already. And like I always say, if you want to be one of the first people notified when I drop some of the straight game, please do me a favor and click on what appears to be that little bell notification right below this video. I'm going to get right into it. Ladies and gentlemen, what I have is the bombshell opposition motion. I did a live on it the other day, but I'm going to show you this is the part right here that's really intriguing to me, if you will, and it should be intriguing to you. I'm gonna get right into it, and this is towards the end of the motion, the opposition motion that the state, or should I say the prosecutor, filed in reference to Kefee D's motion for bail and to get out on his own personal recognizance. And I'm going to get into it like this. Is B, defendant's multiple confessions along with testimonial evidence presented at the grand jury established proof evident and presumption great of defendant's guilt, right? It says here, defendant has confessed to being the leader of the Southside Crips during the time of Shakur's murder. He openly declares that if the Southside Crips was an army, he was the general. He states that the death row beatdown of his nephew, Orlando Anderson, gave him the ultimate green light on Shakur and Knight. He admits to obtaining a firearm for the purposes of seeking and confronting Shakur and Knight. He puts himself in the white Cadillac with Southside Crips that were subordinate to him. He admits to providing the firearm to the shooter. He admits to telling the driver of the Cadillac to turn to confront Shakur and Knight. He admits to being in the car with his soldiers during the shooting and then instructing them how to act after the shooting. Defendant has bragged about his role in the murder of Shakur and mocked the manner in which Shakur died. Defendant has even confessed to attempting to receive payment from Sean Combs for the murder of Shakur. The admixture of defendant's multiple confessions with DeAndre Smith's confession, with Lee's, Ladd's, and Wright's testimony of the gang dynamic in play, along with the eyewitnesses' accounts that corroborate defendant's testimony, all demonstrate what defendant has said in many different ways for over a decade. Dwayne Kefee D. Davis orchestrated the gang hit of Tupac Shakur as retribution for the beating of his nephew Orlando Anderson. To aid his defense, defendant now claims that he is merely a prolific liar and not a murderer. The state submits that both can be true. Defendant claims that his recall of events were for entertainment. But who exactly was he entertaining when confessing to the Las Vegas Metropolitan Police Department homicide? See Exhibit 1. And if defendant's position is that all his confessions are false, that would certainly allow for the admission of his conversation with the federal task force that defendant references. See Exhibit 5, report of defendant's December 18th, 2008 interview with the Joint Federal Task Force. In small writing, and this is very important, to be clear, the state did not admit defendant's proffer to the federal task force to the grand jury. As noted by defendant's motion for bail, A recording of his confession to the murder to a joint task force was publicly distributed in 2015. If defendant's position is that his statements are all lies, then his proffer would certainly be admissible at trial. But Kefee D's lawyer, the public defender, did not admit that in their argument for bail. And so what the prosecution is basically saying is, well, if he's saying that they all lies, then basically, he lied to the federal joint task force also, and he could be now charged for those other crimes that they gave him the proffer agreement for. The facts as they relate to the proffer are somewhat relevant to his position that the proffer was compelled. Moreover, that statement by a defendant to California or federal authorities is protected by a proffer agreement is unclear because they haven't seen the proffer agreement. Most of the information of the alleged proffer can be gleaned from public information. Sometime around 2008, defendant was caught in a sting operation by task force of federal agents and local law enforcement in California. At that time, defendant cooperated with authorities, provided what limited information he had concerning the Christopher Biggie Smalls Wallace murder investigation. During that time, law enforcement also learned about the defendant's drug connections as well as his knowledge related to the Tupac's murder. It is the state's understanding that defendant cooperated in setting up a high-level drug transaction for the task force in an effort to work off his charges. Additionally, on one occasion, an United States attorney sat down with the defendant pursuant to a written proffer agreement that provided him protection for that one conversation. That one conversation. Look how they're putting that one conversation. On some of the various internet and television accounts, recordings of defendant with the California authorities appeared to have been part of the programs. Whether these recordings were created in that singularly protected proffer session or during other conversations with law enforcement is unknown. Based on the inability to know the circumstances of those recordings, they were not used at the grand jury, meaning they don't have the actual recordings from the proffer agreement session with the Joint Federal Task Force and LAPD. Defendant next argues that the most compelling evidence that defendant was not involved in the murder of Shakur comes from the mouth of Marion Suge Knight, defendant's motion bail, page 13. Defendant cites an interview Knight gave to the TV show TMZ. However, in a subsequent interview, Knight implies that DeAndre Big Dre or Freaky Dre Smith is one of the Southside Crips in the car responsible for Shakur's murder. In that interview, Knight takes issue with Calvin Brodus Jr., Snoop Dogg, for his lack of loyalty to Shakur. Knight and Death Row, specifically Knight, references Brodus, and I'm going to go into the smaller notes because this is very important. It said, this appears to be corroborated by defendant's NCIC does not reflect any arrest or conviction associated with his 2008 contact with authorities. Despite numerous efforts, the state has not been able to acquire the actual proffer document from either California federal authorities nor defendant pre-indictment counsel. Likewise, the FBI 302, which is Exhibit 5, was prepared on March 16th, 2009, describing a December 18th, 2008 conversation. It does not mention the AUSA or any sort of proffer protection. However, out of an abundance of caution, the state did not present evidence of that statement at the grand jury. Then they referring to the collect call with Suge Knight on Breakbeat Media. But going back to the actual specifically, Knight references Brodus's recording of a song on the album of someone who was part of the murder of Shakur. The album Night is referring to is DeAndre Freaky Dre Smith's album, Hard White, on which Broadus records the song When You Livin' the Life. Knight further clarified that when he said free Kefee D, it was not because of the defendant's guilt or innocence, but rather that Knight is opposed to prison for anybody regardless of who the person is. Knight then opines about defendant's statement stating that if any of this shit is true and I ain't here to say what is and what's not, he is safer in prison than he is on the streets, meaning Kefee D is safer in prison than he is on the streets if any of what the evidence and the things that the Kefee D had said about himself is true. It is no secret that Knight has not cooperated with law enforcement during any aspect of the investigation into the shooting that injured him and killed Shakur. But that defendant's most compelling argument that he is not responsible for Shakur's murder rests on Knight's wholesale stance against incarceration demonstrates the overwhelming evidence, largely from defendant himself, that defendant is responsible for the murder of Shakur. According to defendant, Tupac chose the wrong game to play and the wrong niggas to play with. Suge and them should have done a better job of protecting Tupac because they knew who the fuck we were and what we were capable of. Grand Jury Testimony, Volume 6, page 63. Davis wanted the world to know what he did and what he was capable of. Now this court knows, and accordingly, the defendant must be held without bail. Damn, Kefee D put himself in a hell of a predicament, man. All of that posturing and, you know what I mean? Once again, the best thing that you can possibly do when being arrested is keep your mouth shut. And evidently, as the gangster that Kefee D claims to be, he had missed that class in regards to being a criminal or being a under police custody or under police investigation, if you will. Then it goes into the defendant's, the credible threats that we heard of. And this is the actual, like I said, it's the actual document. Defendant's credible threats to witnesses demonstrate both a consciousness of guilt and that defendant poses a danger to the community. Since his incarceration, defendant has made numerous statements which demonstrates his consciousness of guilt. As it relates to this motion, the state will limit the discussion to the safety threat he poses to the community. Since the grand jury transcripts became public, a number of defendants' phone calls have focused on witnesses in the case. Much of the IRE has centered on two witnesses, Reggie Wright Jr. and Lee. Additionally, at the request of the presiding criminal judge, they relating to the, in a smaller line of notes relating to the Suge Knight collect call, the state was asked to help the public defender conduct a conflict check, right? Did y'all hear that? At the request of the presiding judge, criminal judge, the state was asked to help, the public defender conduct a conflict check. The state provided information related to a witness as well as the list of known Southside and mob members who were part of the search warrant in Compton in 1996. See Exhibit 3. Deputy Public Defender David Westbrook provided this list to the defendant despite not being appointed to the case. Defendant told his son that the people on the list were witnesses who had cooperated with the investigation. Based on the phone calls, either defendant or Mr. Westbrook provided the same list to defendant's son. The photograph of the list was then distributed for what can only be surmised as a means of dissuasion. See Exhibit 4, right? On October 9th, 2023, approximately 01:05 hours, defendant called his wife and his son. Davis Jr. During the call, Davis Jr. told defendant to call him in the morning. I got something to tell you about some shit that's going on. Defendant asked what, and Davis Jr. stated around the city they were talking about it's a green light on our side. Davis Jr. stated they said we was raised in war. We don't give a fuck. When defendant questioned what was going on, Davis Jr. told him the nigga B. Rue, defendant asked if he was gone. And Davis Jr. said he was saying it's on. Davis Jr. then told the defendant he would talk to him tomorrow. See Exhibit 5 DVD call 10/9/2023 at 0105. Edited to begin at approximately 4 minutes and 40 seconds into the call. The defendant's world, a green light is an authorization to kill. This caused enough concern that the federal government stepped in and provided resources to at least Mr. Lee so he could change his residence. Wow. And like I said, I read the previous convictions before, but I'll do it again. Defendant's previous convictions show his danger to the community. It seems like, Kefee D doesn't mind being locked up, man. Defendant's first arrest occurred in 1993 for grand theft and robbery. In 1984, he was arrested for shooting into an inhabited dwelling, but it was reduced to a misdemeanor in 1985. His first 2 felony convictions occurred in 1985 for narcotics in California, both possessions and transport to sell. In 1986, he was convicted of possession of narcotics for sale twice, was sentenced to his first prison sentence. After his parole in 1998, he was convicted of possession of a controlled substance. In 1988, In 1998, he was convicted federally for conspiracy to distribution of cocaine and was sentenced to 70 months with 5 years supervised release. He was released on supervision in 2002, but revoked in 2005. In 2013, he was arrested for possession of concentrated marijuana and a felon in possession of a firearm. After his arrest, he fled the jurisdiction of California, moved to Henderson, Nevada. In 2015, he was convicted of gun charges and sentenced to 16 months in a California prison. The conclusion. Here, the defendant confessed over and over that he was responsible for the murder of Shakur. Now, finally facing the consequences of his actions, defendant asked this court to ignore his words, to ignore words to the Federal Joint Task Force in 2008, to ignore his words and his voluntary statement and to the Las Vegas Metropolitan Police to the Las Vegas Metropolitan Police Department in 2009, to ignore his words from his interview to producers in 2017, to ignore his words from his own book in 2019, to ignore his words in his interviews from 2020 up until his arrest. The state maintains, however, if one merely listens to defendant's words coupled with the testimony elicited at the grand jury, the proof is evident and the presumption great that Dwayne Kefee D. Davis orchestrated the murder of Tupac Shakur. Signed by the prosecutor in the case, Stephen B. Wilson, Clark County District Attorney. Yeah, it's crazy, man. Wow. And then at the end of the thing, this is interesting when you deal with it. Say, finally, should the court set any monetary bail, no matter how high, the state will request a source hearing. Defendant has no financial ability to pay for either his bail or his attorney. However, he has been shopping the story of Tupac's murder through agents to pay for both. Such financial gain would be in direct violations of Nevada's Slayer statute. See NRS 41B 200. So they're basically saying Kefee D is shopping his story to basically pay for his bail or his attorneys, because he can't pay for either right now. So basically that's what's going on behind the scenes. Amazing. Yeah, tell me what you guys think in the comments, man. Your boy DELRAY, straight game.